Hello, good evening. It is Friday, December 5th, and this is going to be a really short one. I'm just going to read the latest response from Kelsey Fitzsimmons camp. It's in response to the Commonwealth's brief in the SJC. So, and it's not very long. It's only, I think it's 14 pages long, so it won't be very long at all tonight. I hope everybody's doing great. I hope the start of your weekend is going good. Happy Friday. And is everybody ready for Christmas? Because it is just around the corner, and I'm telling you, it's coming on fast. Also, Brian Walsh trial had I think it was like a half day today. I saw most of the proceedings today. I missed the tail end, and I also missed the tail end of Anna Walsh's boyfriend taking the stand. I saw most of his testimony as far as as far as the direct goes, but I didn't see much of the cross by Mr. Tipton. So I'm going to have to go back and watch Melanie on that because I'm sure Mr. Larry Tipton just, kind of made him sweat a little because he was making Connor Keefe sweat today. But I didn't like the look of Anna Walsh's boyfriend. He looked angry. He had a big chip on his shoulder from what I saw. So I think he's very bitter. And I think I don't know, he didn't seem too torn up about Anna being gone. If you ask me, I don't feel like he seemed too upset by that. I feel like he was just put out by having to come to um, court, having to come to Boston, testify. So, anyway, let's get to it, shall we? Sorry about the rough look, but um, I just came in from rowing. And so I thought, well, I better do this now or I'm not going to do it. So here I am. Alrighty, so Kelsey Fitzsimmons, appellant slash defendant v. Commonwealth. Reply brief for appellant Kelsey Simmons. We have a table of contents. I'm not going to read those because I'm going to read it as we go. So let me make sure that you guys are seeing what I'm seeing. Cool. So introduction. Now comes appellant Kelsey Fitzsimmons and respectfully submits her reply brief in the instant matter. The Commonwealth's submission to the full bench, that didn't take long, did it? What is that? The second sentence? Wow. The Commonwealth's submission to the full bench dramatically expands its position in far beyond the limited scope asserted in the trial court hearing under appeal, and raises new issues that were neither presented nor litigated by them below. Appellant addresses those new contentions herein in the context of the appeal, whether the Superior Court's revocation of release issued sua sponte, without notice, without proper findings, and without adherence, constituted an error on law warranting relief under SJC Rule 2:21. So, it's kind of irritating how the Commonwealth, during that hearing where Kelsey Fitzsimmons' bail was revoked, even though they're saying it wasn't revoked, it basically was revoked. When they took her back into custody, the Commonwealth didn't have much to say at all about it. The only thing he was concerned about is whether she was going to be, tested for alcohol or not while she was out. Other than that, he didn't give a shit if she was out or not. And now all of a sudden he's got so much to say. I think he's just afraid of Judge MacArthur, is that her name? McCarthy? Layman. I think the Commonwealth, the prosecutor's just afraid of her, and so he didn't want to say anything in front of her, but now he's got just a big old mouth, and he's got just tons to say. And I think it's too little too late. They need to just deny his motion or his brief. Anyway, argument. Roman numeral 1. The Commonwealth's brief improperly expands the scope of the appeal. Before the Superior Court, in the hearing at issue here, the Commonwealth stated only one simple request: to maintain alcohol monitoring. Appellant, held under the court's order, agreed in principle, but by a different means, and the parties were not in opposition on this issue at the hearing. The probation department likewise agreed there was no violation. Despite this narrow framing, the Commonwealth now submits a 41-page brief addressing everything under the sun, disputed facts, praising and defending the Superior Court's actions, and presenting a narrative far beyond the scope of the question that was before this single justice. This expansion is inconsistent with the procedural posture of the appeal vis-a-vis the Commonwealth, and obscures the core issue, the lawfulness of the Superior Court's sua sponte revocation of bail. That's all. And it definitely does. It's drawing attention away from that, totally. Roman numeral 2. The Commonwealth relies on allegations the grand jury did not credit. Yeah, because the grand jury didn't come back with an indictment for attempted murder or anything else. They tried, but they didn't come back with it. They just did the assault with a dangerous weapon. The Commonwealth's principal factual argument relies on the assertion that appellant pointed a loaded firearm at a colleague, pulled the trigger, and attempted to fire again. These allegations were presented to the grand jury. If credited, they would have supported the requested charge of armed assault with intent to murder. The grand jury rejected that theory and returned only one count of assault with a dangerous weapon, an entry-level Superior Court offense. Yeah, she would have gotten out on her own recognizance, and I think it's a maximum, 3 years in jail? By the time they go to trial, she could have served the 3 years, but it's the principle of the matter. You know what I mean? She doesn't deserve it. She deserves to be an officer again, an officer, if that's what she wants. I don't know. I don't even know if she wants to go back to that, but she deserves to have the opportunity. It shouldn't be taken from her. The notion that appellant intended to murder a colleague cannot be treated as a credible allegation when the grand jury declined to indict on that basis. Yet, the Commonwealth's brief repeatedly presents these rejected allegations as though they were findings of guilt or fact. Dangerousness determinations must be tethered to reliable evidence, not accusations that failed at the grand jury stage. Roman numeral 3. The Commonwealth lacks a standing to defend the Superior Court's sua sponte revocation. I like that word, sua sponte. It means spontaneous, right? Unplanned, I think. Because the Commonwealth neither requested revocation nor argued for detention. That's true. They didn't care one way or the other. In the hearing at issue, it does not have standing to defend the Superior Court's sua sponte decision. The Commonwealth's stated position below was limited to seeking alcohol monitoring. Monitoring. That's it. Monitoring. Appellant agreed to, although only under the umbrellas of the trial court's disputed release framework, provided it could. Let's start that whole sentence over again. Appellant agreed to, although only under the umbrella of the trial court's disputed release framework, provided it could be administered in a manner compatible with her documented injuries. Because remember, she's got broken ribs, a popped lung, hemothorax, and you could die pretty quickly from a hemothorax. Your lung is collapsed and your chest is filling up with blood. That's what the heme is. The pneumothorax is the popping of the lung. So you got heme and pneumothorax, hemopneumothorax, or a hemothorax. And you can die pretty quickly if you don't get that decompressed and get that lung reinflated. It can put pressure on your heart. You go into torsades. It's a whole big thing, So she was in bad shape, and that doesn't heal fast. Plus, when they put a chest tube in you, they make the smallest incision, but then they dig their fingers in the incision to get through the meat between your ribs. And this is literally what they do. They just put the two fingers in there and just, bore through till they can get a good sized chest tube in there. And they're not gentle about it. And the chest tube is very rigid, It's not like really soft, mushy plastic. It's pretty rigid because it has to be able to poke through muscle and tissue. And so just healing from the chest tube alone is very painful. Not to mention she had a popped lung, so that's got to heal. This judge is a piece of shit, basically, for having no empathy at all for Kelsey. I mean, she must have never, ever been hurt a day in her life because she's got no empathy for Kelsey. It's unbelievable. I wonder if she's even got kids because, like I said, she's got no empathy at all for Kelsey. She just doesn't like her for some reason. It seems that way anyway. That's how she appears. And so if she doesn't feel that way and she doesn't mean to come off that way, then she needs to take a good long look at herself in the mirror because that's how she's coming off. So anyway, the Superior Court nevertheless revoked bail without a motion from the Commonwealth, without notice to appellant, and without findings under 58A or 58B. An argument not raised below is waived under Mass R. Criminal Paragraph 30. I don't know what the C stands for. Sorry. Thus, a party cannot defend on appeal a ruling it did not pursue below. Makes sense? Roman numeral 4. The Commonwealth's assertion of trial readiness lacks support in the record. The Commonwealth asserts that it will be prepared for trial in January, a backdoor way of saying the wrongful incarceration of appellant, quote, won't be that bad, end quote. But at the time its brief was filed, it had not furnished automatic discovery, had not identified the firearm allegedly used, and had not provided materials necessary for independent expert review. I don't know why. I'm sure this happens everywhere, but it's pretty out there in Massachusetts that the Commonwealth just doesn't like to hand over discovery, apparently. I mean, it's a fight. Every trial we have watched or even watched, covered, or whatever, even if we just touched on it a little bit and didn't watch the whole thing, the discovery is always an issue. I mean, the Commonwealth just feels like they are above the rules. They can do as they see fit because nobody holds them accountable. I mean, it's insane. They're supposed to have discovery in by such and such date, and they're like in trial. Trial has started, like in the Karen Reed case, and the defense is still not received a good portion of the discovery from the Commonwealth. It's insane to me. That's a reason for an appeal, as far as I'm concerned, right there off the bat. I mean, if the person's found guilty and you never got all the discovery before the trial began, I feel like that's automatic appeal. It should be an automatic mistrial, but like with Judge Canoni, that's never going to happen. So, yeah, there's that. Assertions of trial readiness are not relevant to the question at hand. In any event, are not supported by the current state of the record. Roman numeral 5. Appellant's physical injuries were serious, documented, and directly related to her inability to perform SCRAM testing. The Commonwealth states that appellant offered no medical evidence demonstrating her physical condition. How about spending 55 days in the hospital? Or how about the fact that she had 6 or 7 pretty big major surgeries? Or how about the fact that she's got bullet fragments still in her back? Or how about the fact that, I mean, you can go on and on and on. And they're saying that she didn't give them she offered them no evidence. Are you fucking kidding me right now? That is so unacceptable. I mean, they're just making shit up now. This is incorrect. The severity of appellant's injuries, a punctured lung, fractured ribs, and other gunshot-related trauma was obvious, documented, and reflected in official reports. Probation staff witnessed her difficulty performing SCRAM breath testing due to her injuries. I mean, they arraigned her from her hospital bed, for Christ's sake. She was handcuffed to her hospital bed the whole time she was in there, and that's where she was arraigned from. So what do you mean she didn't show any medical evidence? I mean, you expect her to bring the bullet fragments in that they removed? Or what? How about the blood out of her chest? You want her to bring that into you to prove? Is that evidence enough for you? I mean, get the fuck out of here with that. Nonetheless, the Superior Court failed to consider the impact of these injuries on appellant's ability to comply with the condition imposed. The issue before the court until the trial court's surprise SCRAM ruling was her mental state and lack of dangerousness, as supported by 2 esteemed mental health clinicians. You see what that says? Lack of dangerousness. Not her physical disability. Yeah, they never mentioned the physical disability being an issue. They were worried about her dangerousness and her mental health history, right? They didn't want her to be a danger to the community or to the victim, Noonan. And they were worried about the community safety with her loose, like she's some big psychotic serial killer or something. I mean, Jesus. I know. I mean, I've seen people out on bail for murder, cold-blooded murder, that aren't being monitored as closely as Kelsey Fitzsimmons is. So explain that to me, why that is. Because this judge has a hard-on for Kelsey Fitzsimmons for some reason. I don't know what it is. She just doesn't like her. And she doesn't like Mr. Bradel either, which, how can you not like Tim Bradel? Oh my God. He's adorable. The Superior Court did not address the two expert opinions from Dr. Nisevic of Massachusetts General Hospital and Dr. Zeisel, concluding that appellant did not present a danger to herself or others. Underlined, exclamation point, whatever. Number 6, contrary to the Commonwealth statements, appellant proposed a reasonable alternative to scram testing. The Commonwealth asserts that appellant presented no alternative to scram health testing or breath testing, which is complete bullshit because Tim Bradel was trying to suggest a few things and the judge just got up and walked out. He was mid-sentence and she left the bench. I mean, what's that about? I mean, what the fuck? The record directly contradicts this claim. Appellant proposed urine testing through a probation-approved vendor and alternative Assistant Chief Probation Officer January identified as feasible. The Commonwealth's repeated statement that no alternatives were offered is inaccurate. Yep, I heard the audio of it. Number 7. The procedural complexity below resulted from the court's unexpected concerns. The Commonwealth characterizes appellant's litigation posture as quote-unquote piecemeal. Here, repeated filings were necessary to address matters unexpectedly raised by the trial court's positions that alcohol testing was indicated, urine testing was unknown to it, and the claim that what proof did it have, parents, to already filed affidavits that appellant's rib injury made it difficult to breathe deeply. Appellant's filings addressed issues as the court raised them, not by choice, but by a necessity. Well, and it's not like she couldn't do it or refused to do the scram testing. She just asked if there was an alternative because it was so painful and it caused her to be in so much pain for the rest of the day. But if you don't have an alternative testing, then she was willing to stick with the scram testing. She was just thinking maybe there was something else they could do because every court deals with DUIs. And you can't tell me that this judge didn't know of any other options for testing for alcohol. Bullshit. I call bullshit on that. Number 8, the revocation cannot be upheld under either 58A or 58B. The Superior Court's revocation of release did not comply with either statutory scheme. I sound drunk. I don't know why I have a lisp all of a sudden. A, if treated under 58B, required procedural protections were absent. Revocation under 58B requires notice, they didn't get, a hearing, they didn't get, findings of willful violation or new dangerousness, they didn't have. None of these occurred. B, if treated as reconsideration under 58A, due process was still required. The appellee stated that the decision was, quote unquote, not a revocation, but rather a reconsideration, quote unquote. Sorry. If treated as reconsideration under 58A, due process was still required. The appellee stated that the decision was not a revocation, but rather reconsideration. Regardless of label, 58A requires notice and an opportunity to be heard before modifying a release order. Appellant received neither. Appellant's liberty may not be revoked under a statute that does not permit revocation based on the facts at hand, particularly without observing the procedural safeguards required by due process. Number 9, footnote 8, footnote 9 of the Commonwealth's brief contains significant misstatements. Footnote 8 presents a characterization inconsistent with the record and unsupported by any judicial findings. Footnote 9 misstates the role of the full bench under SJC Rule 2:21, suggesting that the full court is limited to reviewing the single justice's determination. In fact, where the single justice makes an error of law, the full bench performs de novo review and resolves the underlying bail question to prevent further unnecessary delay, and a remand to a lower court judge who would have already made an adverse and then reversed ruling, consistent with Stack v. Boyle. Number 10, the trial courts and the Commonwealth's discussion of mental health history omits the uncontroverted expert opinions. The Commonwealth references appellant's mental health background without acknowledging the 2 expert evaluations concluding that appellant was not a danger. By 2 mental health experts, they found that. These opinions are unchallenged in the record and must be considered in any dangerousness analysis. If they didn't challenge them, then they didn't feel that she was dangerous. So why now is it an issue? 11, alcohol use played no role in the underlying incident. And that's what I've been saying all along. They act like she's some big drunk. She got drunk at her bachelorette party. Big deal. Who doesn't? I mean, if there's no drinking at a bachelorette party, why have one, right? I mean, what are you just going to sit around and drink tea? I mean, for Christ's sake, it's a party. And how else are you going to get your nerve up to put dollar bills in the stripper's G-string if you're not drunk? Just kidding. But I mean, who doesn't drink at their bachelorette party? I don't think I've ever met anybody that didn't. And the people that I did know that got married and don't drink, they didn't have a bachelorette party, because that's what it's all about. Bachelor and bachelorette parties, that is all that it's about, is drinking and tying one on and letting the chips fall where they may one last time before tying the knot. It is what it is. So they're acting like she was breastfeeding. She couldn't have been drinking on a regular basis anyway. The allegations concerning alcohol derive from an affidavit submitted in a separate context by an individual with motives unrelated to the criminal matter. Justin, they're talking about Justin. He had to make it look inviting for a judge to give him custody of the baby. And how else are you going to do that except to make her look like she's an unfit mother? You're going to bring up her mental health, which she's, overcome and got her job back and everything. But did he tell the court that? No. Got her guns back. You just made her sound like a drunk with mental health issues, So of course the judge is going to grant him an emergency custody. It was bullshit. It was chicken shit the way he did that. And I have no respect for a man that does something like that. I have none. And then he moves back home with his parents. What the fuck is that? You can't take care of your kid on your own? No police reports or charges are extant from this alleged behavior at a bachelorette party in Maine. No witness has been cross-examined or questioned under oath as to any of this alleged behavior. There is no rational basis to credit this piece of paper filed to gain advantage in a custodial family court matter. In contrast, Law enforcement officers present on the day of the incident did not report that alcohol was a factor in any way whatsoever and found a normal mother happily at home with her 4-month-old baby. Sitting on the couch, I believe she was nursing the baby at the time because they had just gotten home from being stood up by Justin. Told her to bring the baby and meet him at a park, and she waited there for 3 hours. Little did she know, one of his friends was watching her and keeping Justin apprised of her whereabouts and what she was doing, so that he could go to court and file for emergency custody without her knowing. And so he knew if she was tied up at the park waiting for him, he was safe. But he actually had a friend watching her and keeping him posted as to what she was doing in case she figured something was up. What a piece of shit. It was totally planned. The trial court's revocation cannot be justified based on untested allegations unrelated to the incident, particularly in the shadow of the mountain of evidence to the contrary. I mean, if she was really unhinged, wouldn't you want the judge to see that? So bring her to court. Face off with her in court. But he knows that she's not going to come across that way because she's not that way. She has no more mental health issues, and she's not a drunk, so she's not going to come off that way, and he's going to lose. So he had to do it behind her back and make her look as bad as possible. The Commonwealth did not address the ADA argument in its brief before the single justice and therefore waived it. Appellant argued before the single justice that scram breath testing was medically impossible due to her injury and that the Americans with Disabilities Act required a reasonable accommodation. The Commonwealth did not respond to this argument. Its first discussion of the ADA appears in the appellate's full bench brief and was ignored by the Commonwealth in the single justice session. And all they said about it in the full bench brief was that they didn't feel that she qualified as an American with a disability because it didn't affect her day-to-day living. And all I have to say to that is not being able to take deep breaths. I mean, since when is breathing not a daily necessity? Not only an activity, but a daily necessity. I mean, what the hell are they talking about? I mean, COPDers are on disability, and that's a breathing issue. Hers wasn't more of an acute situation, but you can be disabled for a period of time. You know what I mean? You don't have to be disabled. Doesn't mean that you're disabled for the rest of your life. Anyway, under Rule 116A, 9 and 9A, arguments raised for the first time on full bench review need not be considered. And I agree with that. If they didn't even, address it, they ignored it. They acted like it wasn't there in the first single justice session. So as far as I'm concerned, they waived their right to argue that point. You can't bring it up now in the full bench and think that, oh, okay, we're good. It'll still work. Conclusion. For the foregoing reasons, Ms. Fitzsimmons respectfully requests that the Supreme Judicial Court, 1, address the bail determination de novo consistent with the applicable case law, and 2, grant Ms. Fitzsimmons liberty with personal recognizance and a stay-away order from the alleged victim under Section 57, parents, no finding of dangerousness required, or Section 87, bail terms imposed with agreement of the defendant, of the bail statute, and vacate the balance of the trial court. And vacate the balance of the trial court order, including the provision handicapping the probate and family court from handling the custody and visitation decisions in the case, and or 3, grant other such non-incarcerative relief in the alternative if the court deems 58A conditions necessary. And 4, send the case back to the Essex Superior Court before a different judge. He does not want that McCarthy Layman or whatever her name is, for the reasons set forth above. Wherefore, Ms. Fitzsimmons respectfully requests that the Supreme Judicial Court justices enter the appropriate orders as above. Respectfully submitted on December 3rd, 2025, Timothy Bradle and Martha Coakley. So, that is it. So I told you it's going to be a short one tonight. So hopefully you were able to tolerate me long enough to watch it. And I hope everybody has a nice weekend. I don't know if I'm going to be coming on again this weekend. Depends on what kind of updates there are. I heard Mark Batterow came out with another brief brief or statement or something. And so I'm going to try and get that, and maybe I'll get that and go through that on Sunday or something. But yeah, so I hope everybody has a really good weekend. Stay safe, stay warm, and stay out of jail. All right? I thank you so much, and I appreciate you being here. Take care.